Greetings, law fans. This is Attorney Jeffrey Howard. Once again, joining you on Legaleze 101. This is episode 8, and we're going to go on a limb here. We're going to talk about dog bite claims. Yes, I know. Generally, legalese is about one little term, one little phrase that Jeffrey expounds on and explains and makes clear to the world at large. But today, I'm going to talk about an overview of the topic, dog bite claims. The reason why is I've been getting a lot of dog bite claims recently, and this area of the law in North Carolina is kind of odd and kind of confusing, so I thought I'd at least take an effort to give a general overview of dog bite claims in North Carolina, just to expose you to some of the terms and some of the concepts, and that way it'll help people out in order to determine whether or not they might have an actionable dog bite claim. So we'll get started. 2 ways to pursue a dog bite claim in North Carolina: the vicious propensities angle or the general propensities angle. We're going to talk about the elements that you have to prove for each route: the general propensities, the vicious propensities, and then we're going to talk about their differences, their similarities, and then a few of the little concepts involved in there. Just a few, because there are so many, I couldn't do all of them. So first we're going to start with vicious propensities. 4 elements. The defendant has to have been the owner or keeper of the animal. The animal caused injury or damage. The animal was dangerous, vicious, mischievous, ferocious, or one term in law is possessing a vicious propensity. Love that. The defendant had actual or constructive knowledge of the vicious propensity, character, or habits of the animal. It's the final element. So those are the 4 elements. I know, a lot of stuff. Second angle is the general propensities angle. First 2 elements are identical to the other one. The defendant is the owner or keeper of the animal. The animal caused injury or damage. When I say injury or damage, by the way, I mean injury to a person, damage to property. It's just how they phrase it in the law. The animal's conduct should reasonably have been anticipated by the defendant, owner, keeper, and the defendant failed to exercise due care to prevent injury done by such reasonably anticipated conduct by the animal. I know, there's so much legalese in there. I could probably do a year's worth of legalese episodes on just some of the terms in those 2 routes of doing dog bite claims. Don't have that much time today, so I'm just going to touch on a few little things. Technically, dog bite claims aren't negligent claims. It doesn't have to do generally, mind you, I have to have that caveat, with how you're keeping the dog or whether or not you're exercising reasonable care. But the general propensities angle essentially goes to the level of a negligence claim because you deal with a reasonable person standard, which is what you do in a negligence claim. What would a reasonable person do? That's how you define negligence generally, or what is a negligence, what a reasonable person would do. In the general propensities angle, you have to reasonably anticipate what the dog or the animal is going to do, and you should have reasonably anticipated what that conduct that he's known to do would cause. For example, it gets a little simpler when I give you an example. Let's say you have a big dog, 150 pounder or something like that, and it jumps on people all the time. Super sweet dog, just wants to lick them in the face, never hurt anything, sweet, sweet puppy, not a vicious animal, but jumps on people. Well, let's say that animal jumps on someone, just doing its normal big hug thing, knocks the person down, they break their arm. Well, you're probably on the hook for that because in that situation, you should have reasonably anticipated that conduct because the dog jumps on people all the time. And you could have exercised more care to prevent the injury done by the anticipated conduct of the animal. That's essentially a reasonable person standard, right? I mean, it sounds almost exactly like a negligence claim, although the case law is fairly clear that it's not a negligence claim. These are just labels. You still have to prove what you have to prove. One of the other interesting things about dog bite claims is that the state health director can label particular dogs as dangerous dogs once they have done certain things to people and they cause certain injuries, and you can look at the statute and see what qualifies for that label. Once they've done that, then that owner has very specific, strict rules about what they have to do to keep the animal and not be on the hook for any damage. But essentially, they're going to be on the hook for any damage. I mean, that's just really going to be the situation. So once the dog is labeled as a dangerous dog, it's a bad situation for everyone involved. One of the other very interesting things about dog bite claims is that when you have a dangerous dog that has been labeled as such, you can, or the owner can open himself or herself up to punitive damages. Big deal. Generally, whenever you have a legal claim in North Carolina or most states, you can get compensatory damages, meaning the person is going to be responsible for the harm they've caused, medical bills, pain and suffering, lost wages, those sort of things, things that resulted as or were incurred as a result of the conduct. But punitive damages are different. Those are damages that are allowed in certain situations in North Carolina to essentially punish the wrongdoer, to make them less likely to do that sort of stuff again. Particularly when you have a labeled dangerous dog, if you can show malice, I think we all know what that is, or willful and wanton conduct, which is essentially acting in blatant disregard of other people's safety, then you can possibly get a jury instruction on punitive damages, meaning the jury will be allowed to punish this person with a monetary penalty that would go to the injured party. Now, the punitive damages will be limited, based on North Carolina law, to the greater of 3 times the compensatory damages or $250,000, whichever of those two is greater, as I said. So, interesting stuff, no doubt. Dog bite claims in North Carolina are odd and somewhat difficult, and if you've got a dog bite situation, I urge you to call me, because they can just be very difficult to navigate, and hopefully I can help you out. Well, once again, I hope you've learned some interesting and helpful stuff here, Legaleze 101, and hopefully you'll join me again. Thanks for coming. We'll see you next time.